So my name is John Yanchunis. I'm with the law firm of Morgan & Morgan to prove that the contingency-based practice is alive and well in the U.S. My firm has over 800 lawyers and almost 4,000 employees. And we only do contingent-based work representing consumers. I have with me today some distinguished panelists. Lara Melrose, who's the Litigation Finance Portfolio Advisor for Orchard Global Asset Management. Michelle Reed, who's on the other side of the V from me, with Akin, Gump, Strauss, Hauer, and Feld. And then John Barrett, one of Arthur Bryant's partners at Bailey Glasser. So let me start the conversation. And privacy is a big part of my life. Try to maintain privacy. I'm not on Facebook. I'm incognito mode when I on Google, but so much of our information today is out there, and what I like to describe information is the new oil. It is now the common currency of the 21st century. Some of the biggest companies on the face of the earth, certainly in the US, are Facebook and Google, Amazon, and the first two companies make nothing. They, however, monetize the information that we provide to them, sometimes involuntarily, sometimes voluntarily. So, since we're in the UK, and I was unhappy to receive an email from Lara last week about this case called Lloyd versus Google. Let me start with Lara and ask, Lara, where do you think that decision leaves mass privacy litigation in the UK?
Thanks, John. Before coming on to some sort of detail on the Lloyd and Google decision, I think it might be helpful just to touch on the available mechanisms in the UK for bringing data privacy claims on a group basis, and there aren't many of them. Really, the only other mechanism outside of the representative action is group litigation order, or GLO, and some of the other panelists today have touched on the difficulties with that particular mechanism. So it's essentially an opt-in procedure which is intended to allow the efficient management of claims that have similar issues of fact or law. What they require is a book build up front, and as part of that book build, also an individual assessment of each claimant that signs up a claim. And that means they are extremely expensive to run, and there is a very significant upfront cost. The panel earlier before lunch talked a little bit about what's feasible in book builds. And in the UK, we certainly haven't seen the kind of book builds that result in hundreds and thousands or millions of data subjects who've had their rights breached signing up. I think one GLO that has been successful was the British Airways GLO, which settled earlier this year. That was related to a cyber attack back in 2018. And I think it's just interesting that the advertising costs to build a book of 220 claimants there was over £1 million, and that's just 5% of the eligible class. So I think GLOs are really challenging to make work, where you've got a data claim where the per capita damages are merely a few £100s. So where that's left us is the representative action, which is what the mechanism that was used for Lloyd and Google. I'm sure most of you in the room are very familiar with that case, and have read the Supreme Court judgment last week, which has helpfully provided us with sort of lots of content for today. So that judgment, it was one that has been celebrated, I think, by data controllers and defense lawyers, and read with some disappointment, to put it mildly, by privacy and consumer campaigners, claimant lawyers, and their funders. I'll touch briefly on the detail of the case. So it related to allegations in 2011-2012 that Google tracked Apple iPhone users around the web, collated their data, and used it for commercial purposes without their consent or knowledge. And it resulted in the claim, which related to breaches of the old data protection legislation, the 1998 Act, which obviously has been replaced by GDPR. I think following a case called Vidal Hall, the state of the law under the 1998 Act was that you could claim compensation for breaches of the Act that resulted in material damage or distress. Now that isn't appropriate where you're trying to bring a representative claim because you can't look at the individual circumstances of each claimant. And so the way the Lloyd case was framed, which was extremely innovative but ultimately fatal to its progress, was that it brought a claim without having to rely on proof of material damage or distress. Instead, it relied on loss of control damages. So just the fact that a data subject's rights had been breached should give rise to compensation without needing to show anything more. In a nutshell, the Supreme Court unanimously disagreed with the way Mr. Lloyd had brought his claim. They found that a representative action could be brought to establish liability in that kind of claim, but if you wanted to get damages, you would need to go away and bring individual claims or on a group opt-in basis. And that's because loss of control damages aren't available under the 1998 Data Protection Act. Lord Leggett, who wrote the judgment, went further and said, even if loss of control damages were available, the claim still wouldn't have succeeded because you would have needed to look at the extent of Google's unlawful processing in each case in order to arrive at a damages sum. I think Lord Leggett was very focused on the compensatory aspect of damages under the old Act and the need for individualisation in Mr. Lloyd's claim. So that was the end of that case, which is disappointing news. But I think it's not all bad news. The judgment's quite helpful in that it provides genuine clarification of the scope of the representative action procedure and where it could be used with success. For example, Leggett was clear that in looking at the same interest requirement under the relevant rule, it's not necessary that every class member shares all of the same interests. There can be some divergence of interests amongst the class, as long as there's not a conflict of interest. And I think that has lowered the bar a little bit for representative actions. So that is helpful. He also noted that these sort of claims could be brought. It wasn't appropriate for Mr. Lloyd, but there are other cases where, as he put it, the representative action can be a flexible tool of convenience in the administration of justice. So I think you might see representative actions now being brought outside of the data privacy sphere, for example, product liability claims, perhaps shareholder actions. But I think most interesting is the door was left just slightly ajar for data privacy claims in the context of GDPR. I noted that this case related to the old legislation. Lord Leggett was very deliberate in not considering GDPR and the relevant case law around it. If you look at that regulation, there is a statutory right for compensation for material and non-material damage, and you see the concept of control and loss of control in the Act. So GDPR is about empowering data subjects and empowering control over data. Various of the recitals talk about control. So recital 7 says natural persons should have control of their own personal data, and recital 85 provides that a personal data breach may, if not addressed in appropriate and timely manner, result in physical, material or non-material damage to natural persons, such as loss of control over their personal data. So I think there is a possibility that we could still see some GDPR claims brought through the representative action tool. I think if they cross the de minimis threshold, if you could avoid the kind of individualisation that Lord Leggett didn't like about the Lloyd case, and which, where you could come up with a methodology for calculating damages that's common to the whole class. Whether that will happen, we'll see. There are, I think, 6 or 7 representative actions that were stacked up behind Lloyd following the Court of Appeal judgment, the Supreme Court decision. Some of those will fall away, I'm sure, because they are based on the old Act, but there are some that are relate to breaches of GDPR, and I'm sure there are some creative lawyers and some brave funders who are willing to see if those kind of claims can survive. Just one other point I would make is that I think what this shows is that we do need some legislative intervention to legislate for a dedicated mechanism like we have in the Competition Appeals Tribunal for bringing collective proceedings there and breach of competition law. The government's failed to take up this previously. They decided not to implement Article 80 of GDPR, which would have provided a similar kind of mechanism. But interestingly, in their decision, they pointed to the Lloyd case as a potential available mechanism. Now that doesn't appear to be available. It'll be interesting to see if decision makers in the government decide to look again at the issue.
Thank you, Laura. Michelle, the litigation in the U.S., what and how are these claims being litigated?
So the U.S. has obviously a more developed system on the class action side than you see in the U.K. And I think you're probably more familiar in terms of bringing the claims on the plaintiff side. On the defense side, the way we see it happening is after any data breach or a privacy incident of a significant size, we see class actions being brought, and usually multiple class actions. And so depending on the number of people impacted, they'll end up with a handful of class actions, or sometimes you'll see dozens or more class actions, in which case then we have a procedure in the United States whereby those multiple class actions can be consolidated into what's called multi-district litigation. And in connection with that, you see the plaintiff lawyers being very creative in the way that they approach it. There are some instances in which you see statutory regimes being developed in the United States that allow for these claims. So specifically, the California Consumer Privacy Act, the CCPA, has allowed for a private right of action in California, and that has statutory damages attached to it. In other instances, you don't see the private right of action that is in statute. And so in other states, you have to have, you see breach of contract. If there's some sort of, contract that could be alleged, you'll see breach of implied contract. You'll see things like unjust enrichment and many other different types of claims that are brought. And they're all brought in the class action context because obviously for damages of this amount, it's not worth it to a single individual to bring the case. That's an overview of sort of how they're brought in the United States.
John, can you add anything to what Michelle just discussed?
Sure. I just think it's interesting coming at this from the perspective, like you, John, of being a consumer lawyer for so many years and litigating consumer class actions. Typically, we litigate consumer class actions under statutes, but here we have no real statutes to litigate under. To the extent there are private rights of action for data breach, those private rights of action are limited to particular states, and even there, they're limited to very particular circumstances. So as Michelle said, these gaps, these interstices have been filled by lawyers bringing claims under common law. We're talking about, common law with its origins in the King's Court, 1066, following the Norman Conquest, and ancient laws that are being used to apply creatively to very modern situations. And as Michelle said about the creative work that's being done, John, you in particular have done a lot of work in framing damages. And I'd like to turn the tables on you a little bit, and perhaps if now is the time, perhaps to address some of the work that you have done and the work that you have noticed to frame damages in data breach class actions.
Certainly, I think probably since plaintiffs' lawyers are contingent-based, we have to be very entrepreneurial, we have to be very creative, because we don't receive any compensation, obviously, unless we prevail. And many times we fund our own litigation cost and expenses, and in the class action context, that can be expensive. In 1999, I filed a case against a company called DoubleClick, which doesn't exist today. It was gobbled up by Google. And in 1999, when the internet was fairly new, certainly it hadn't been monetized to the level it is today, DoubleClick would place a cookie on your hard drive. And the cookie would follow you wherever you went on the internet. Consumers, of course, at the time didn't appreciate or know that the cookie was on their hard drive. Computing capability of computers at that time was very small, so the aggregation of cookies would cause poor performance of your computer, such as slowing it down. So we filed a class action, others followed, and there was what they call in the US a multi-district litigation formed. The cases were placed in New York, and we began litigating that case. Now, without a statutory framework at the time, and as we'll get into later, not much of one exists today, we had to come up with claims. And since the US adopted common law, when we became a nation back in the 18th century, we got together and found one that fit: trespass to property. The property of each consumer was their computer, their hard drive. The trespass was DoubleClick placing a cookie on their hard drive. That claim was the way in which we settled that as a class case. The problem at the time was DoubleClick had no money, so the type of relief was mainly based upon injunctive relief, better business practices, and now we know the cookie became one of Google's methods of monetization, although they've just recently discarded the cookie and they've got new technology that tracks us around the internet. So over the course of time, and that was not a data breach, the earlier cases in the early 2000s were based upon data misuse, and then it wasn't until probably 2012, 2013, when large retailers first began to get hit by hackers and extracted from computer systems was credit card information, names and addresses, and thieves, being very innovative folk that they are, began to duplicate the credit card information and engage in fraud. Probably the next major development in a class case involving data breach was the Target data breach, of which I was in leadership. It affected 100 million residents in the US and many residents in Canada, as Target, a shopping store, had many stores in Canada. The company lost $10 billion of market cap within the first month of filing. We litigated that case. Again, another MDL was formed in St. Paul, Minnesota. Eventually, after several years of both litigation and mediation, we resolved that. And again, not being necessarily as creative as we would later become, the case was settled for about 10 million US for 100 million people. Not very much. The next major case was, I would say, Home Depot. It affected 65 million US residents. Home Depot is a hardware store extraordinaire, very large. And from that point, cases began to be hit in various sectors. So we had retailers with credit card information being taken. It then migrated over to other types of industry. We had the Equifax case, which is a major credit bureau. 145.5 million Americans lost our unique identifier, which is a key to opening up all kinds of financial transactions in the US, Social Security numbers. And that case was settled for, depending upon how you look at the value, about 1.6 billion US, $345 million in compensation. I'm now involved in a case called Capital One, one of the largest credit card companies or banks in the US. And 97 million Americans had 21 bits of information taken. That's about half the adult population. And that case has been taken further than any other case in the US. That's putting aside the Facebook case that we got certification of a class, one of the first ones for injunctive relief. Facebook lost 40 million users' information worldwide. And then one of my partners was able to certify for damages a credit card breach involving a series of restaurants. So each time we've litigated these cases, we've kind of pushed the envelope of thought, both in terms of liability, expanding in large part the use of common law claims, some statutory state law-based claims, and the concept of damages. And I want to talk about Capital One for a moment, because I think that probably is the most advanced case in terms of the concept of damages. So one of the things that we've been litigating for the last couple of years is the value of people's personal identifiable information, PII, is the way we refer to it in the US. And there is one place where PII is valued. It's on the dark web. The dark web is a place of the internet that none of us ever want to go unless you want Interpol or Scotland Yard or the FBI to track you. But it's the place in which hackers, cyber criminals, go to engage in their type of commerce, including placing information up on the dark web for sale. And it has value. Depending upon the type of data element, it has a value that the market has set. And we have used that in a damage model in seeking class certification. I settled a Google case last year using that model, and we're facing a contested certification in the Capital One case in the Eastern District of Virginia, and that judge has that motion pending. Another concept of damages that we've used is the cost to any one individual through the loss of that information. And what is that? Each of us who've lost information through a data breach or a data leak or a data compromise face the present and continuing risk of identity theft. And in the US, we have a type of product that protects us. It's called identity theft protection, sometimes referred to as credit monitoring, but the concept of the product has advanced to do better detection of the way in which our identities may be abused and used by a cyber criminal to monetize it. So in the Capital One case, the first case we've ever tried this, we've taken an actuary who's taken the birth dates of 97 million individuals. He's figured out what the life expectancy of every one of those individuals would be based upon mortality tables, which is accepted in the actuarial profession, which works within the life insurance business, and figured out, based upon each one of those 97 million Americans, how long each will live, based upon those mortality tables. Then we've taken the cost of an identity theft protection product, applied that across the class for those years, and then brought it down to a present-day value. And we're seeking that amount of money from Capital One, which was argued by the defense to be too extreme. It's $500 billion. And as I argued to the judge, if I represented a consumer in this courtroom and was seeking $10,000, would you find that offensive? Of course not. The fact that 97 million people had their information taken, that's not their fault. That's the company's fault for having poor cybersecurity and not protect that information. So that motion remains pending. We'll see what the judge does with it. We may end up owning Capital One. The last concept is one grounded in common law. It's nominal damages. So in the US, in almost every state, I'm going to leave Louisiana out. I hope I'm not offending anyone. Louisiana adopted civil law. The rest of us adopted common law, and I could not go into a court in Louisiana, state court, and really understand what was going on. But in the 49 other states in the US, we have a concept of nominal damages. That is where there's an infringement of a right. The law presumes that in the absence of actual damages, there must be some damage. For every wrong, there's a remedy. It's a concept in Roman law. It's a concept in equity in the UK. So we're arguing that at bottom, in the alternative, if the judge disallows every other damage theory, the court or the jury could award nominal damages. And in the US, we have, certainly courts have, or juries have awarded a dollar. In Virginia, which is fairly conservative politically, they've awarded $100. $100 times 97 million would be quite a sum of money. But again, it's not the fault of any one of those consumers that their information was taken. That's Capital One's fault. So when I read the decision, I saw, one, great promise in the representative action and the ability in the UK to expand judicial thought. Because the law is constantly expanding, it's not contracting. We're taking 18th century concepts in the US, 19th century, excuse me, based upon a privacy, which is the first time it was really recognized, and applying it to 21st century technology. And that's where the tension lies, is taking the past and marrying it with the present and the future. And that's the promise I see in the UK.
I mean, I would completely agree with that, and I think the, those cases that you've just described are clearly extremely innovative and creative, and you're having to fashion solutions to deal with modern problems, as you described. And I think the Lloyd case was a really good example of the role that these kind of class actions group claims have in ensuring that the law and our processes, our procedural mechanisms, keep up with the developments, particularly in the data sphere. So, big tech is a vast industry. It's moving very, very fast, and there's a risk that the law falls behind. And so I think, there is an obvious role that these kind of cases play. Lloyd, unfortunately, wasn't successful, but what he did achieve was expose the gaps in the law that there are at the moment, and the need for something to be done to fill those gaps.
And again, one of the things I want to do, Lara, is I want to go back and look at the pleadings or the file in the Lloyd case to get a better understanding of what was being argued. We have very similar cases in the US because, as I mentioned before, data has become the new currency of the 21st century. So if information is taken from consumers without their acknowledgement and consent, as I understand it was in the Lloyd case, and a company makes money, in the US, we've got intellectual property rights. So for instance, if there's copyright infringement or patent infringement, you don't measure damages based upon what the plaintiff lost. You measure it by what the defendant gained. And in this case, in the Lloyd case, I wondered why wasn't the argument, don't look at what the consumers lost in terms of the right to control their information, but what did Google make? And why isn't that the measure of damages? And then divide that up equally among every member of the class. That would have been my approach, but again, that may have been the approach in the pleadings, and I mean no disrespect, but when I looked at it, that's what I thought. And perhaps if you look at some of the cases I'm litigating in the US, you might find some of those theories. And again, that's an expansion of the law in privacy, and it comes from the intellectual property side of what we're litigating in the US. So we'll see where it goes.
Yeah, I don't think Lord Leggett would have liked that very much, seeing as he was so focused on the compensatory aspect of damages, but I entirely agree with you. It's a relevant way of looking at it.
I'd love a chance to argue in front of him if I were so licensed in the UK. So,
well, speaking of argument, do you mind if I jump in a little bit on damages in the
please.
US from a defense perspective? I hear everything that you're saying about the way plaintiffs approach damages, but I'm sure the audience won't be surprised that defendants approach it a much different way, and our evaluations are much different and generally speaking much lower. In the United States, typically, when you have a data breach that impacts a piece of personal information that could be used to really commit some kind of fraud, like a social security number, which in the UK, I think is your national insurance number. Typically, even though it's not legally required under most states, there's a handful of states where it's legally required, companies will issue this identity theft protection. It involves credit monitoring. It has insurance for in the event that your identity is stolen. It has the ability for you to call a hotline. And if you did have your identity stolen, you can call them up and they will help you sort of recover all of that. And you don't have to do any of the work associated with that. So in light of the fact that that is how most companies respond, our position, generally speaking, from the defense side, is that they don't have damages. We're already insured to the tune of usually $1 million. We don't see identity theft damages even going anywhere near that amount. We've already provided credit monitoring, and we've also provided individuals who are able to help you with that. So there's a very limited, in our view, a very limited amount of potential damages. And a lot of what we're talking about is speculative. I might be harmed sometime in the future. And there's a huge split in the United States on courts that recognize whether that is sufficient harm to confer standing. For many years, it wasn't sufficient harm almost all the way across the country. And then over time, that changed, particularly some decisions coming out of the Ninth Circuit and the Seventh Circuit, so California and the Illinois, Chicago area. You saw some change and some movement where the plaintiff lawyers were getting standing. But the question of damages is still another question. And when you look at the valuation of the data, a social security number on the dark web sells for a very low amount, pennies. It doesn't sell for thousands of dollars. It sells for a very low amount. And so when you practically look at what the value of the data is and how long it's really maintained, we don't see the same amount of damages. Where there's, I think, some risk to defendants and where it becomes more complicated is in the statutory penalty area. So when the legislature decides that a certain action, if taken or not taken, results in a particular damage amount, which, for example, under the CCPA in California ranges between $100 and $700 an individual, then that's where you start running into some real damages. But even with that private cause of action in California, they specifically have a requirement to be able to maintain that in the law, that they violated some duty to implement and maintain reasonable security procedures and practices. And so these damages are not necessarily just guaranteed. There's a data breach and therefore we have statutory damages. That was only one of several hoops that you have to jump through in order to get it. And even those statutory damages vary based on intentionality. Where we've seen a huge uptick is in Illinois, under the Biometric Information Privacy Act. And under that, and that's where one of the really large Facebook settlements came from. And under that decision, or under that statute, there were statutory damages for if you don't follow some very specific requirements on how to handle biometric information like fingerprints and face scans and other things. And in those instances, because it originated from Illinois state court and it was an Illinois state court statute, there was a decision that came out of the Supreme Court of Illinois that essentially conferred standing for virtually just like the fact of the statutory penalty alone was enough. And so you saw this huge proliferation of class actions related to the BIPA in Illinois because you could get that statutory class action penalty. I don't personally think that you're going to see that uptick across the United States. I think there's going to be a lot of pushback on sort of the plaintiff's approach to damages, particularly when you look at the thought of, is it fair that one error on Capital One results in, an entire class and plaintiffs owning Capital One? We can all debate about that, but likely, I think we'd all fall out that there are some shareholders that should own Capital One too, and that damages need to be a reasonable amount, particularly where, although it's a difficult process, you could change something like a social security number through a process. So I know I've talked too long, but.
Of course, I disagree, but I'll say mine. I'm very passionate about consumer privacy, as you might be able to tell. John, any response from you?
Well, I was hoping to hear your response, John. So, No, I think I'd love to hear your response on that.
So, yeah, most Americans who have been surveyed, and I think this probably goes with the world, believe that their information should be maintained private. Obviously, we have a choice, and sometimes we give certain bits of our information on Facebook. I told you I'm not on it. You'll find my profile there because you can't get off of Facebook. But I choose not to go back on it because I found what Facebook does not to be to my liking. But the fact is that people value their information, and I think what Michelle and I have a tension, and we're both on opposite sides of the V, is I believe it has great value, and I think it has more, our Social Security number, than just a few pennies. And the fact of it is that the more and more breaches there are merely increases the risk. It doesn't decrease it. And the fact that I've been the subject of maybe the Equifax breach doesn't mean that every criminal on the face of the earth has that information. Because again, there are places on the dark web that you simply cannot Google or find that information, or you need some type of bona fides to be able to gain access. And it would cost you, I believe, more than a few pennies. But the concept still, and again, it's one of the things I talked about. If there's a violation of your rights, shouldn't you have at least some way to address that? Certainly, Lloyd versus Google, perhaps not at the moment. But if the concept of nominal damages is alive in the system in the UK, like it is in the US, why can't that be at least, at bottom, a level of damages? And shouldn't, as we have in the US, the jury system, make a determination of what that means for every consumer? Now, it may be in the extreme case that we don't end up owning Capital One, and that's not my purpose. But still, we've argued to the judge, award everybody $100 or $10. Is that unreasonable? No. And I think it, as again, we see the expansion of the way in which information is used and misused, not just in data breach litigation, but also in the way companies monetize it. There is, without question, this massive movement of information. And companies today aren't just selling products. They're gathering information that we give to them when we buy that product. Or we think that we're getting something for free, like on Google or Facebook or Twitter or TikTok. Now, those enterprises exist because we give them something. It's what they do with it that I don't think anyone has an appreciation of. And I have a real concern. And I don't live in a box. You Google me and I'm all over the place. But still, I still value what I put out there. And I think I'm entitled to compensation as I seek compensation for every one of my clients in class litigation where their information is taken. But again, we're trying to take 19th century concepts, perhaps some even older in the UK, and marry it to a change in the way we live today with technology. So one of the things, Laura, if you could, turning to the next topic, talk about how the regulatory regime for data privacy might affect litigation in the future. And I think you talked about it just briefly, but if you could expand on that.
Yeah, sure. So I think when we're thinking about the UK, it's relevant that the government is currently proposing to overhaul, or is consulting on proposing to overhaul GDPR and replace it with a regime which they describe as pro-growth and pro-innovation. I think these proposals have been met with mixed reactions, and there have been concerns that they are too data controller friendly because they seem to be targeted at sort of lessening the compliance burden on data controllers. And it's not clear what impact that will have on data subjects' rights. And I think, the proposals also involve reform of the Information Commissioner Office's role as well. So I think there is, in the proposals, an acknowledgement that the ICO is overburdened. you just need to look at its annual report from last year, which shows that just a relatively small proportion of data breach reports that are made to it were the subject of further investigation. You know, it's failed to issue any GDPR fines against big tech. It's really not done very much to address the ad tech sector and real-time bidding. And so I think this just serves to highlight, again, the need for mechanisms which allow data subjects to get redress when their rights have been breached and supplement the enforcement regime. You know, as John was saying, data sort of permeates every aspect of societal transactions, and the fact that the ICO could fine companies 4% of their annual turnover doesn't address the fact that they aren't able to get compensation for data subjects and where their rights have been breached. So I think, you know, it's really crucial. The government is consulting. I mentioned that they didn't implement Article 80. They are consulting on expanding the regime in the CAT. I very much hope they do that and they expand it to data infringement claims.
Thank you, Laura. So, Michelle, going across the bond, what do we find in the U.S. in terms of statutory and the regulatory framework?
Very different than GDPR. I think if we meet back in about 15 years, it'll probably look similar, but right now it looks very different. In the United States, each state has its own regime in which they regulate. And then at the federal level, so across the United States, there are also statutes that regulate privacy and data security. These statutes in the United States are sectoral. So you'll see, you know, big issues and discussion and law on healthcare. So, you know, if you're a hospital or some other covered entity in the United States, HIPAA has been very long lasting. If you are a government contractor, there are some very specific requirements for government contractors. If you're dealing with children's data, there are some very specific, you know, federal across all of the United States requirements related to children's data. But because of the sectoral approach in the United States, it's been a little bit more difficult to get traction on the regulatory level. And what we see is, you know, different regulators regulating in different ways and not necessarily coordinating. And so that happens at the federal level. The Federal Trade Commission has been the principal regulator in the United States, but then also at the state level through state attorneys generals. And so when states are dissatisfied or, you know, upset about something that has happened, you will see them intervene. And so certainly California has been a leader on that, but we're seeing action kind of all over the United States where these new statutory regimes are coming into play that are providing certain you know, privacy rights to individuals.
John, does the absence of a uniform regulatory framework make litigation more challenging? And if so, how?
Well, absolutely. So typically the way these cases are pursued is, again, on a class action basis. And we typically do class actions under federal and state statutes. The question in certifying a class action, deciding whether a case can go forward as a class action, is a central question is whether there are common issues presented across the board among all of the class members. And when all of the class members have claims that arise under individual state laws, it's very difficult to make that argument, and courts generally have not accepted those arguments. So nationwide class actions are very, very difficult to bring in the absence of a statutory regime, and that's why you fall back on the common law claims that we've been discussing. There is one development on the horizon which will be interesting to watch, and that is that the Uniform Law Commission, which in the United States has brought us the Uniform Commercial Code, which is a statute that every law student in America knows and governs sales and secured transactions and any number of commercial transactions. The Uniform Law Commission brought that to the states for adoption, and they are also bringing a Uniform Personal Data Protection Act into the states, introducing them into state legislatures in January of this year, just in a few months. It's not a strong statute from my perspective and from the consumer's perspective, but it does provide some measure of uniformity.
So 2 years ago, I went to Tallahassee, Florida, which is the capital of the state of Florida. It's very conservative. And I lobbied for a privacy bill and argued for about an hour and a half on each of the 10 amendments I had to a pending bill. All were shot down. And then something happened in the last election cycle in the U.S. Our then president, Trump, lost his ability to tweet and to be on Facebook and Instagram. And suddenly the Republican or conservative movement in the U.S. thought that it was their ox now being gored, to use the biblical framework. And I went back to Tallahassee, and now there was great excitement about this privacy bill. So I had for a long time the attention of both members of the reigning parties, the Democrats and the Republicans, to pass this bill. And similarly, there was this hue and cry in Washington to change it, and then it dissipated. So in Florida, they did pass a privacy bill, but unfortunately, the big business got in at the last minute, and really no consumer has any rights. It's the right of government to police Facebook and Twitter and all the other media sources. So we're somewhat back to square one. And in a way, politics plays a part, doesn't it, John? In the at least in Washington.
Yes, it does. Virginia passed a statute very recently, and there was one business in particular that is credited with having tremendous input into that statute, and that is Amazon. So you can imagine that that is not the most consumer-friendly statute that could have been enacted. There just isn't, seems to me, political will to take care of this situation. And that's where lawyers step in. You know, in 1954, there wasn't political will to desegregate the American public education system. That was brought about by lawyers bringing constitutional claims in the Supreme Court, resulting in the Brown versus Board of Education decision, which predated federal statutes prohibiting discrimination by 10 years. So perhaps that's where we'll be in the United States. Lawyers in the courts, litigants bringing these claims to force change, to force businesses to be more careful with the way that they handle our very important information. That, in the absence of political will, seems to me to be where we're heading.
Thank you, John. So our last topic, just kind of a general question to each of you. Lara, what do you see as the hot topics in data privacy litigation in the UK?
Well, I think apart from the impacts of the Lloyd judgment and the need for sort of a legislative intervention, I think until that happens, probably the trend will be away from the UK system and looking to our friends in, for example, the Netherlands, who have a far better, it seems, mechanism for bringing these kind of claims. I hope that, you know, that also has some influence in the decision makers here as to whether they decide to try and make sure that we catch up and provide the right mechanisms for getting redress in the UK.
Michelle, what do you see as the hot topics in the US?
I think you're going to see a lot of class actions related to privacy as opposed to just data security. And I think you're going to see them sort of plaintiff lawyers looking very closely at how you're using your data and how it's disclosed under your privacy policy. And I think they're going to try to find creative ways to hold companies accountable for the way they disclose, the way they use it, and the way they in fact use it. And that will be driven in large part on, whether they're able to get traction on damages, a huge part of the discussion today. Because if they are, I think you're going to see more and more of that type of litigation.
Thank you. John?
So some of these state statutes that do exist that govern data breaches and data privacy can be enforced by state attorneys general. They can't be enforced by individual litigants, that is my clients, but they can be enforced by the state AGs. So I think you may see state AGs partnering with the private bar to pursue these kinds of claims. That is something for which there's a great deal of precedent in the United States. And I've done that work for attorneys general and myself as a private member of the bar. So I think you may see some developments in that arena.
I agree with Michelle and John, and I think what you're going to start, will remain for some time is data breach litigation. Information being taken, the level of cybersecurity measures being taken by companies is more than one mistake. It's poor. That may change with the tightening of cybersecurity insurance, and there is a hardening of the market presently in the U.S. I think the insurance industry has been trying to figure out what happens when information is taken. One of my adversaries is here, Paul Carlsgott, or was earlier. He and I are in litigation constantly, and his client is mainly the insurance company. So I think there'll be a change. And I think the biggest area in the future is data misuse, the way in which companies collect information, do not give clients or consumers clear and conspicuous notice of what they're doing with that information, and companies believe it to be their own information and they monetize it. Capital One, for instance, following the filing of a large retailer, which was one of its card member partners, meaning if you went into, I think, a Neiman Marcus or a Lord & Taylor, I forget which one of those, and you got a credit card, it was supported by Capital One. And when that company went into bankruptcy, Capital One claimed the information of consumers held by that retailer was their information. Well, we abolished slavery much later than you did in this country, and no one owns any one of us. So I was offended by that. Now, perhaps that was theoretical when they claimed that information was ours. No, it's the consumers. We can't give ourselves to somebody. But what we can do, and this is the paradigm I'll present to you, is we can license it, right? We can't give our name away, but we can license somebody to use it in the way we believe as a consumer it should be used, not misused. Any questions from the audience? Any off the internet? Okay, well, thank you so much. Thanks for each one of my panelists. They are astounding lawyers in their respective fields, and thank you for your time today.